In Section 11.1, we covered statutory and contractual disclosure obligations. Now we move into warranties. Disclosure tells you what is known. Warranties define what is promised. This section shifts the transaction from investigation to acceptance. It clarifies that the property is sold in its present physical condition while also preserving specific legal protections that survive closing. In the metropolitan Phoenix market, where resale homes range from 1960s ranch homes in Tempe to newer builds in Queen Creek, understanding warranty language prevents post-closing disputes and protects brokers from claims based on misunderstandings. This is where contract language allocates risk clearly and intentionally. Condition of premises. As is, with maintenance obligation. The contract states that the premises are being sold in their present physical condition as of the date of contract acceptance. Seller makes no warranty, express or implied, regarding condition, zoning, or fitness for a particular use. This is often referred to as an as-is sale. However, it is not a waiver of disclosure obligations. The Arizona courts have made clear that as-is language does not protect a seller who fails to disclose known material defects. Phoenix example seller in Mesa sells home as is. Seller knows of ongoing foundation settlement but does not disclose. Buyer discovers cracking after closing. The as-is clause does not protect concealment of a known latent defect. The clause limits implied warranties but does not eliminate the duty of honesty. At the same time, the contract requires seller to maintain the property in substantially the same condition through the earlier of possession or COE. Seller must also remove debris and any personal property not included in the sale. Chandler example. After contract acceptance, monsoon storm damages fencing. Seller must repair or maintain substantially same condition prior to COE unless parties agree otherwise. This clause protects buyer from deterioration during escrow. The contract also reminds buyer to conduct independent inspections during the inspection period. Negotiations regarding repairs are permitted but not required. Any agreed repairs must be handled under the inspection resolution section of the contract. This reinforces that inspection rights, not warranties, are the buyer's primary protection. Warranties that survive closing, post-recording protections. Most contractual obligations merge into the deed at closing. However, certain warranties explicitly survive COE. These include seller warrants disclosure of all known material latent defects. Seller warrants payment in full for labor, professional services, materials, fixtures, or tools furnished within 150 days preceding COE. Seller warrants accuracy of sewer or on-site wastewater connection information to the best of seller's knowledge. These surviving warranties are significant. Scottsdale example seller hires contractor to replace roof 2 months before closing but fails to pay contractor. Contractor files lying after recording. Seller warranted payment in full. Buyer may pursue seller for breach of surviving warranty. Gilbert example seller represents property connected to municipal sewer. After closing, buyer learns septic system exists. Seller warranted accuracy to best of knowledge. These provisions protect buyer from hidden financial or infrastructure risks that may not surface during inspection. Mechanics line risk. 150-day lookback. The 150-day lookback period aligns with Arizona lien statutes. Contractors who perform work may have statutory rights to record liens if unpaid. The seller warranty that payment has been made protects the buyer from inheriting lien exposure. Agents should ask sellers early in escrow whether recent improvements were completed and paid in full. Documentation should be retained in the file. This is risk prevention in action. Buyer warranties, performance and acceptance. Buyer also makes warranties in this section. Buyer warrants that buyer has disclosed any information that may materially and adversely affect ability to close. Buyer has conducted all desired inspections and investigations. Buyer accepts the premises at the earlier of possession or COE. Buyer is not relying on verbal representations not documented in writing. This clause is critical in reducing post-closing claims against sellers and brokers. Tempe example buyer verbally asks listing agent whether home has ever had termite treatment. Agent responds informally. Buyer does not include termite inspection or written contingency. After closing, termite evidence appears. Buyer claims reliance on verbal statement. The contract states buyer is not relying on verbal representations unless disclosed in writing. This reinforces the importance of written documentation. Verbal representations. Document everything. Arizona transactions must be documented. Verbal assurances are unreliable and legally vulnerable. Professional agents train clients to put all material concerns into writing, either through contract terms, inspection notices, or amendments. Queen Creek example. Buyer relies on seller's statement that irrigation line was replaced. No documentation requested. After closing, irrigation fails. Buyer struggles to prove reliance. Written communication protects all parties. Negotiation is permitted, not required. The contract clearly states that buyer and seller may negotiate repairs but are not obligated to do so. This is important in competitive Phoenix markets. Sellers are not automatically required to fix inspection items unless agreed. Understanding this reduces emotional conflict during repair negotiations. Why does the contract state the property is sold in its present physical condition, but still require disclosure of material latent defects? Answer: because as-is limits implied warranties, but does not eliminate the seller's duty to disclose known material defects that are not readily observable. Why do certain seller warranties survive closing? Answer: because they protect the buyer from hidden financial liabilities, unpaid labor claims, or misrepresented infrastructure conditions that may not be discovered before recording. Why is the clause about not relying on verbal representations important? Answer: because it reinforces that enforceable obligations must be in writing and reduces disputes based on informal or undocumented statements.